Hey everybody, this is Mr. Maupin coming at you here with an APGov video focusing in on topic 3.8, which is taking a look at due process as it pertains to, in this case, issues dealing with searches. Now, a couple things to review here. First off, what is due process? Well, due process note is found in both the 5th and 14th Amendments to the U.S. Constitution. The Fifth Amendment version applies to the protections from the federal government. 14th Amendment version applies to protections from the state governments. But what both the 5th and the 14th Amendment due process protections include is that if the government is going to be depriving you of life, liberty, or property, meaning in other words, if they're going to, confiscate your car or imprison you or execute you for a crime, that the government cannot do that arbitrarily. They just can't just on a whim do those things. And the formal steps that the government must follow to be able to actually deny you life, liberty, or property, your basic rights, that's called due process. So, just to give a very basic run through is that, in order to deny somebody liberty, for example, you would have to have some degree of reasonable suspicion or probable cause to stop someone, and to be able to then get a warrant to do a lawful search. And then if that search, provides evidence of a crime that's been committed or being committed, then at the moment of arrest, that person has read their Miranda rights, which we'll get to a little later. And then they are brought before a judge and are formally arraigned. In other words, that formal charges for what crimes are being charged with are actually formally presented to them. The ability to have access to an attorney. The ability of, in a trial, to have a jury of your peers, to be able to provide witnesses on your own behalf, to confront witnesses that have been brought against you. And then, if after a unanimous ruling of conviction by a jury of your peers, after all those steps have been, followed, then and only then can the government be allowed to deny you, in this case, say, liberty by having you go to jail. So that's due process. It seems like there's a lot to it, but it's done for a reason. It's done to make sure that we are not denied our basic rights arbitrarily by the government. So following these steps, following these procedures is critical to the protection of our overall rights. Now, that's applied in a number of different ways. It's applied to the Fifth Amendment, it's applied to the Sixth Amendment, all that kind of stuff. But we're going to take a look at it from the Fourth Amendment's perspective. Now, remember, we talked previously about how the Fourth Amendment protects us from unreasonable searches and seizures. And the language in the constitutional amendment stipulates that you would need reasonable suspicion / probable cause to be able to obtain a legal warrant. Now, we've talked all about that before, and how you determine reasonable suspicion and how you determine probable cause for the general public, all that kind of fun stuff. And that then brings us to a situation of what happens if the government actually violates your rights in an attempt to obtain evidence against you. This is known as, if the government does this, this is not allowed. This is known as the exclusionary rule. So in other words, let's say that, somebody has, a lot of marijuana in their house. The police cannot just barge in the front door and see the marijuana in somebody's house and then, we see the evidence, we see, 30 pounds of marijuana that's clearly being done for trafficking, so we're going to arrest you for drug trafficking. That search was not legal because there was no probable cause as far as the example goes. It was just done on a hunch by the police. No warrant was issued by a judge. So that evidence of the 30 pounds of marijuana could not be used in that defendant's trial because that evidence was obtained illegally. In other words, that evidence was obtained by violating the accused person's rights. So you can't use that evidence. Now, this was first established in the 1914 case of U.S. versus Weeks. But note, this is at the federal level, which means it had not been incorporated yet. For it to be incorporated at the state level, in other words, to protect us from the state governments using illegally obtained evidence against its court, that then brings us to the 1961 case of Mapp v. Ohio. Now, you do not need to know Mapp v. Ohio nor U.S. v. Weeks by name. But it is an important case to understand, basically, that the right to be protected from having illegally obtained evidence be used against you in a trial is protected at the state level. Now, just to give you a little background on that case, the woman, Ms. Mapp, that was the center of this case, basically she was associated with a lot of gangster types in the city of Cleveland in the late 1950s. And the police were searching for somebody that they had a warrant out for their arrest, and they had reason to believe that that this person was at this woman's house, and they did have a right, warrant to go look for this person. So they had a search warrant for this guy. And so when they enter into her apartment with the assumption that, okay, we have a legal warrant to find the guy, and they actually do find the guy that they're looking for, but they also found evidence of various pornographic magazines and stuff like that, and this violated what were Ohio obscenity laws at the time. Now, note, this is well before you had the Roth v. U.S. ruling, or excuse me, this is well before you had the Miller v. California ruling that provided a little bit more, guidelines for that. But anyhow, so they arrest Ms. Mapp on the possession of obscenity charge. Now, she files a lawsuit in court saying that, hey, the police didn't have a right to search through my stuff while they were there. They were looking for this person that had a warrant out for their arrest. And the Supreme Court agreed. They agreed that the search was done illegally, and therefore that evidence could not be used against her. Therefore, the exclusionary rule is applied at the state level. Now, understand that warrants do not have to be perfect to avoid being, tied in with the exclusionary rule. So, like, let's say, for example, that the police issue a warrant to search someone's house at 100 East Main Street, and they go to, 100 East Main Street, or excuse me, they go to, let me start over again, I'm sorry. Let's say the police have a warrant to search 100 East Main Street. However, the house they go to is 100 West Main Street. It's the person they're looking for, and they issue the warrant, they search the property, they find, let's say, illegal drugs there, and they arrest the person, but the warrant was not properly filled out. There was a mistake. They put East instead of West. And so could that evidence be thrown out because that warrant was not 100% accurate? Well, that's considered a good faith exception as far as the court is concerned. The idea being is that if the police are trying their reasonable best to follow proper due process steps, and they make a mistake in that process, but they are, it's a minor mistake, but they're reasonably trying the rest. They're not actively, negligently violating somebody's rights, then that's going to be considered a good faith exception. That evidence would be allowed to be used. Another exception is what's known as inevitable discovery. In other words, the idea being is that, even if the initial information that provides the evidence is obtained illegally, if that evidence was going to be found legally anyway, inevitably, then that evidence can still be used. So let's say, for example, somebody's been accused of a murder, and they're brought into the police station for questioning. Now, we haven't gotten to it yet, but there are protections that you enjoy under the Miranda rules that basically stipulate that you are not compelled to provide any evidence against yourself. In other words, you're not compelled to answer any questions that the police may ask you. Now, that's also including the protection of, knowing that you have the right to have access to an attorney. So let's say that somebody that is a suspect in a murder case is brought down, and they deny this person the access to their attorney per the Miranda rules in the Sixth Amendment, and they question this person, and they deny, or they, refuse to give this person access to an attorney. Now, a smart attorney would tell their client to not answer any of these questions because, that would only potentially incriminate you. But the suspect doesn't know this because they haven't had access to the attorney because the police denied them that right. And so the person does provide information and as to where a body has been found specifically. Let's say it's under an oak tree somewhere in a park. Now note, before that suspect gives up the information as to the specific location of the body that person was responsible for killing someone, let's say the police had already started to conduct a search of that park where they suspected that that body would be. Inevitable discovery would stipulate that that search, which had already started lawfully, would inevitably have found that body, would have found that evidence. And even though the police violated the suspect's rights by denying them an attorney and therefore getting information to the exact spot, that evidence would have been found inevitably. So even though that suspect's rights have been violated, it still does not take away the ability of the police in that case to use the evidence against that suspect. So be mindful of what the exclusionary rule is and some important exceptions with that. Now, another area of focus when we talk about due process and applying the Fourth Amendment is, of course, searches in public schools. And there's a whole litany of issues that go along with that. But probably the most important case that's tied in with it is New Jersey versus TLO from the 1980s. Now, once again, you don't have to know this case by name, but it basically centers on a teenage female high school student that was seen smoking in the women's restroom. The administrator then uses that violation of school rules, smoking the cigarettes, to search. They use that as reasonable suspicion to search that student's purse. The idea being is that, hey, there's probably more cigarettes in there or other contraband associated with what she was doing that was already in violation of school rules and state law, smoking underage. So they search the student's purse. They find, cigarettes, but they also find rolling papers. They find a big wad of cash. They find a list of individuals that owe the students some money, and they basically turn her over to the police, and the police charge her with drug trafficking. The student filed a lawsuit claiming that the school didn't have the right to search her purse, because they didn't have an actual warrant to do that. Now, out on the street, yes, you would need a lawful warrant to be able to search somebody's purse. But what the court rules is that in a school setting, students don't quite have that same level of protection. That, in other words, that lower standard of reasonable suspicion is all that a school needs to search a student's personal property. So be aware of that. A couple of other interesting things that just I found that might be interesting tied into the exclusionary rule is the idea that, for example, if the police wanted to put a GPS monitor on somebody's car and monitor that person's car 24/7, they can't do that without a warrant. The idea being is that, yes, even though people know that on the street they're not going to be in private. In other words, people that are on the street know that they're going to be seen on the street. There is a reasonable assumption that even people on the street are going to realize that they don't expect to be monitored by the government 24/7 if they are driving a car. So you'd have to have a warrant for that. Also, on top of that, there was a case of a police officer that had a hunch about somebody having drugs, takes the drug-sniffing dog to the person's front porch. The dog smells marijuana, and then they get a warrant, and then they search the house, and they find marijuana. And you might think, okay, they found a warrant, they got a warrant, and they found the marijuana. Okay, no big deal. But the idea that the police dog was on that person's front porch, in other words, on that person's property, without reasonable suspicion, without a warrant, that is a violation of somebody's Fourth Amendment rights. In other words, there was no legitimate reason for the police to be on that property when they stepped onto that property. There was no reasonable suspicion to be on there. So understand that there are all sorts of intricacies and boundaries dealing with the Fourth Amendment as it applies to due process. So we'll leave it there for now. We'll come back to some other aspects next time. We'll see you then.